Okay, good evening. Hope it all went well on Monday. Did any of you all get to the improv portion?
Yeah.
No.
Raise your hand if you got to the improv portion. Oh, all of you all did, except for one group maybe? That's pretty good. Because there was a lot of stuff to try to do in one session, but I'm glad that at least that most of you got to the improv part. Good. Okay, well today what we're going to talk about is Evidence 101. And, you know, all the stuff that you would do over the course of an entire semester of evidence is just kind of daunting to think about trying to teach the whole evidence course in one 50-minute lecture. So I'm not even going to try. What I'm going to try to do is to hit what I think are kind of the most important principles of evidence law that you need to take into account in getting ready for your performances. Remember, your first performance is going to be on Monday, a week from Monday, and that's going to be opening statements. Now, for opening statements, of course, there aren't really many evidentiary issues. All you have to do in opening statement, mostly to make it okay, is to say repeatedly, the evidence will show, or I will prove to you, those sorts of things. But this is a good time for us to talk about basic evidentiary principles because you're not doing a performance this Monday. You're going to do one next Monday, and you're going to have the lecture on opening statements by Professor Lassen a week from tonight. So that's why we've squeezed this in. And plus, evidence used to be a prerequisite to this course, but it's not anymore. And I know about a third of you all have not had evidence, so I do think it's useful to go over some very basic evidentiary principles. Now, having said all of that, keep in mind that what I'm doing is just giving you a brief glimpse at a lot of these evidentiary principles, just so you know they exist, those of you who haven't taken evidence. How many of you have not taken evidence? Okay, not too many. How many of you, are y'all taking it now?
Yes.
Oh, okay, well, good, all right. So, how many of you are taking this from me? Okay, well, sorry, you're gonna have to hear this again. My apologies. Okay, so anyway, that's what we're doing here. We're gonna do a blitz through what I think are the most important evidentiary principles that you'll have to deal with, mostly when you're doing your direct examinations, your cross-examinations, and your expert examinations later in the semester. Okay, so off we go. All right, first of all, just some general principles. Keep in mind the difference between everybody's role in the courtroom. The jury, obviously, is who you're going to be making your moot and hypothetical arguments to all semester, a hypothetical jury. They are the finders of fact. They are the people you really are trying to persuade through all of your evidentiary presentations and your arguments. The judge, however, is going to decide what evidence they get to hear. Remember, all these rules of evidence are set up because we are suspicious of jurors. We don't want them to get information that we think is going to lead them astray. The judge is acting as a gatekeeper, letting in some evidence and excluding other evidence. So that's what these rules of evidence are all about, the gatekeeping function or guiding the judge in her gatekeeping function. One kind of fundamental principle, and really, if there was just going to be one rule of evidence, it would be this. It would be that only relevant evidence is admissible. So you need to make sure that the questions you're asking, the documents you're offering are relevant. If they're irrelevant, they're not going to be offered or accepted into evidence. And to be relevant, evidence must be consequential. That means it must bear on some issue that matters in the case. Well, that shouldn't be an issue here. And it must be probative. It must tend to make that issue or that fact more or less likely than it would be without that evidence. Again, pretty easy to do. But also, and this is under 401, 402, those are the two evidence rules. And then also under 403, if evidence is inflammatory, it's going to distract the jury, it's going to be cumulative, it's going to waste time, the judge can exclude it under 403. Now, are these issues going to come up much during the semester? Probably not, but it may be that you might object to some evidence or some line of questioning as being irrelevant because it's off on a tangent, doesn't really develop any of the issues that are in play for our hypothetical, or it could just be unduly prejudicial, and you might want to ask the judge to exclude it under 403. Okay, witness examination, evidentiary principles. First principle is that when you have a witness on the stand, and this is our witness here, Peter Policeman, he is, you're going to ask him some questions about what happened. Can you just simply stand up and right out of the box ask him who shot V and have him say, well, the defendant on trial, he shot the victim? Well, no, because under 602, before you can ask a witness a question, you have to lay a foundation to show that the witness has personal knowledge about the issue. What's the problem? Why can't we just ask him who shot V? The students in my evidence class know why. What's the problem? It's the talking snake, right? If we followed up with this, we could say, Mr. Peter Policeman, how do you know that D shot V? A talking snake told me. He's nuts. He's nuts. We can't ask him that question. Or if he learned that D shot V from somebody on the scene of the shooting who said, oh yeah, I saw the shooter, it was the defendant. That's hearsay. So before you start asking any witness on direct questions about what happened, you need to lay a foundation under 602 that they have personal knowledge about it. So you would ask this simple question as a foundation laying matter. Peter Policeman, were you on the scene of a shooting at Main and Broad Street on January 3rd, 2017? Yes, I was. Did you see the shooter? Yes, I did, with my own eyes. Who was it? It was D. Well, there it is. You've laid the foundation under 602. Not hard to do, but you just have to show that he has personal knowledge. Simple enough. Rule 611, on the nature of the questions that you're going to ask. This is really something that comes up all semester. Can you ask a witness leading questions? Well, Rule 611 says that leading questions should not be used on direct examination except as necessary to develop the witness's testimony. What is a leading question? You're going to spend a lot of time talking about this in your direct examination class and even more in your cross-examination class. A leading question is a question that stuffs the answer in the witness's mouth. So, for example, if I were to ask one of you, isn't it true that the light was red at the time of the accident? Well, I'm taking the answer, the light was red, and I'm stuffing it down the witness's throat. That is a classic leading question. The question has the answer in it. Isn't it true that it was dark that night, ma'am? Well, yes. A leading question typically has only a yes or no as a responsive answer. So, you can generally not do that on direct exam. On cross-exam, however, it's allowed because 611C1 says so. And it's also allowed if the party or the witness on direct is a hostile witness, essentially identified with the other party or an opposing party. So you will get lots of objections if you are on direct and you're asking leading questions. So be aware of this rule and be aware of what's kind of a little harder for beginners to do is to be able to hear when a question is leading or not. Anytime you hear isn't it a fact or isn't that true, you know that's a leading question. But they can be leading for other reasons too, whenever the answer is stuffed in the mouth of the witness. So also be thinking of this, the flow of information that you get from witnesses. You as the lawyer have some control over this. When you're asking leading questions, the witness is just saying, yes, no, yes, yeah. Drip, drip, drip. On the other end of the spectrum is when you just ask the witness what happened on that day, ma'am. And she'll just start by talking about how she brushed her teeth in the morning and go on driving down to work. What you are aiming for is something in between. The problem on the left is that leading questions aren't allowed on direct, generally. And the problem on the right is if you just ask her what happened, she might just vomit into the record lots of inadmissible hearsay, lots of information for which she has no personal knowledge, etc. That's why it's better just to ask non-leading, open-ended questions on direct. and that complies with 611C, well, 611, as we've just talked about. Cross-examination, there is all sorts of law and lore that governs what makes a cross-examination proper. I'm not going to get into this now because really we don't have the time to go into all of the law of cross-examination. And I don't know whether Professor Licen or I will give the cross-examination lecture to you all, but most of what will be in that lecture will contain these rules and principles. We don't get to cross-examination for another couple of weeks. When we get there, when we have our Wednesday night lecture, we're going to bake into that lecture some of these evidentiary principles into that lecture, so I'm not going to do it here tonight. Hearsay. This is really one of the most complicated things you'll do all semester in evidence. And it's daunting to think about trying to do hearsay in 15 minutes or less. But the simple rule is this: hearsay is generally inadmissible unless the rules provide otherwise. Well, that rule is simple enough, really simple. What's hard about hearsay, as an initial matter, is just understanding the basic analysis and understanding what is hearsay. The basic analysis is that you first have to listen to what the testimony is, or what the question calls for, and determine whether or not it is calling for hearsay. What is hearsay? Stand by on that for just a second. Then you need to say, okay, well, it's tentatively decided. It sounds a lot like hearsay. It fits the definition of hearsay under the federal rules. Again, more on that in just a second. Is it defined as non-hearsay by the rules? Even though it walks and quacks and waddles like hearsay, do the rules define it as non-hearsay? And then finally, if it is hearsay and it's not defined as non-hearsay, does it fall under one of the exceptions in 803, 804, or 807? So that's the analysis. You're going to be sitting there listening to your opponent ask the witness questions. And you're going to be asking yourself, does that call for hearsay? When you're framing your questions, both on direct and cross, you're going to want to be very careful to frame your questions in a way that doesn't elicit hearsay. Why? Because it'll draw an objection. Now, what is hearsay? Well, this is the definition. And you can walk around the courthouse and hear lawyers spouting off this definition rote, but a lot of people just don't understand it. Well, what is the definition? Hearsay is a statement made by a declarant while not testifying at the current trial, offered to prove the truth of the matter asserted in the statement. Well, there it is. Very easy to say, but much more difficult to understand. So when are you going to be dealing or struggling with the issue of hearsay? A lot. Suppose you call a policeman to the stand and you ask him, officer, what color was the light? Well, that's an improper question. Why? Because under 602, I did lay a foundation with him that he has personal knowledge what color the light was. I would have to say, well, officer, were you at the scene? Yes, I was. Did you see the light color? No, I got there afterwards. Well, how do you know what color the light was? Well, a witness told me. What did she tell you? That's a question that calls for hearsay. Why? Well, because I've just asked the police officer to recount a statement, and this is the eyewitness on the scene, a statement of the eyewitness on the scene made by the declarant, the eyewitness on the scene, while not testifying at the current trial. He's talking about a statement made on the street. And why am I asking him this question? Why do I want you, the jurors, to hear about the color of the light? Because I want to prove that the light was red. I'm offering the out-of-court declarant's out-of-court statement, namely the witness who told the cop this, because I want you to find that the light was red. I'm offering it to prove the truth of the matter asserted, namely, that the light was red. That's classic hearsay. Now, it wouldn't be hearsay if I was offering it to prove something other than that the light was red. If I was offering it to prove that the witness happened to be on the scene, maybe. So, it's a long way of saying you're going to have to struggle with hearsay. You're just going to have to do it. And in fact, a lot of students who have taken evidence and done okay in evidence tell me that they don't really understand hearsay until after this class, because you don't really understand some things until you start kind of realizing, man, I got to prove that this light is red. And the witness who said it was red is not on my witness list. How am I going to prove that the light's red? Of course, she told 10 people out on the scene that the light was red. How am I going to prove it? Because it's hearsay. Well, wait a second. Maybe an exception or an exclusion to the hearsay rule allows me to get in her out-of-court statement that is hearsay. So, but this all starts, of course, with understanding that it is hearsay. It's a statement made by a witness out of court that you're offering to prove the truth of the matter asserted. And the matter asserted was that the light was red. That assertion was made out of court. It's hearsay. Well, just because it's hearsay, and again, I've got that statement being made out on the street under the streetlights, doesn't mean that it's not going to come into evidence. It means you got an issue that you got to deal with. But it could come in if it's defined as non-hearsay. That's one path in. And it could also come in if it falls under a hearsay exception. So just because an out-of-court statement's hearsay doesn't mean that you're doomed. So, what are the possibilities? Well, let's take the first one. That is a statement defined as non-hearsay. Well, the biggest one of these, the one that is used 90% more, and I just made that stat up, completely just made it. 90% more than all of the others is this, party admissions. If you are representing the plaintiff, and here the plaintiff, and we're just going back to my simple red light, green light car wreck case. If you're representing the plaintiff and you contend that the defendant ran the red light and that your client had a green light, what happens if your client at the scene told the police officer, "Oh, officer, I screwed up, my light was red"? Well, that's bad for you. Can the other side, the defendant, call the cop to testify as to what your client said to him out of court? Well, think about that. Sure, sounds like hearsay, doesn't it? Your opponent is offering your client's out-of-court statement to prove the truth of the matter asserted. What was the matter asserted? That she screwed up and her light was red. Well, that sure sounds like hearsay. It walks and quacks and waddles like hearsay. Sounds like hearsay, but it's not. It's defined as non-hearsay in the rules. Why? Because it's an admission by a party opponent. So any statement by a party in her individual or representative capacity, if offered against her by an opponent, is defined as non-hearsay. And that's what you see a lot of. You see a lot of your opponent's out-of-court statements coming in under this exclusion to the hearsay rule. So, yeah.
I feel like this seems contrary to it doesn't feel intuitive because you would think your opponent would have a reason to lie on you.
Your opponent would have a reason.
Right,
Yeah.
like they have a vested interest in.
But this is the thinking. This is the rationale. Is if your opponent calls somebody from the blue, who says and we're representing the plaintiff in this hypothetical, and out of the blue comes this homeless person who's pushing a cart and then gets on the stand, and the person says, you know, I was out on the scene of the accident and I heard that plaintiff admit to doing everything wrong. She said, she started crying, saying, I did it, all my fault, everybody listen, this was my fault. She must have said it 100 times. Well, that sounds like bull, doesn't it? The plaintiff, is it gonna come in? Yes, it's not hearsay, but this is the rationale. The plaintiff is there, it's her case, right? She can take the stand and say, I don't know who this homeless person is. I've never seen that person in my whole life. Then it goes to the weight. The jury gets to decide whether to believe the plaintiff, who says she never said that, and the homeless person called by the defendant. So, yeah, it's a little counterintuitive that we let that in, but the rationale is a party's always going to be there and be able to say, I didn't say that, or to be able to explain. Okay, so those are all the sorts of party admissions. Just be ready to deal with those. Okay, now there are other types of statements, prior testimony of a witness, prior out-of-court lineup procedures. I'm not going to get into that. Those don't come up very often, but understand that there are other exclusions, not just the party admission. Let's talk about hearsay exceptions. Well, geez. No way. No way. We spend, I don't know, a month talking about hearsay. That's what most of my evidence course is all about. We barely get to all of these in the evidence course. So what do you need to know? Well, you need to know that just because something's hearsay doesn't mean that it's not coming in. It may fall under a hearsay exception. And there are some common exceptions, like, for example, present sense impressions and excited utterances. Suppose that someone was talking to a 911 operator right after the accident, and they're saying, oh my God, I just saw a car wreck, the plaintiff ran through the red light, and oh my God, send an ambulance. Well, if the defendant is now offering it to prove the truth of the matter asserted, namely that the plaintiff ran through a red light, that sure walks and quacks like hearsay. It is hearsay. No doubt it's hearsay, and it's not excluded from the definition of hearsay. It is hearsay. Is it going to come in to prove the truth of the matter asserted by the person on the cell phone call to 911? Yes. Why? Because that lady is excited. She is out of breath talking about what she just observed. And that falls under an exception. What's the rationale? Well, the rationale is if somebody's all excited about something, they're not going to have the ability or the desire to just make it up. I mean, I'm not sure if empirically that is a good rationale for the rule, but that's what it is. That existing state of mind, if somebody is out of court, says, oh, you know, my arm hurts, or I'm feeling down today. Well, if you're offering somebody who overheard that to say, oh, I heard him say that they were feeling down, that their arm hurt. Well, they're offering it to prove the truth of the matter asserted, namely that the person's arm hurt, or that the person really was depressed. But it can come in because of the then existing. Now, again, all sorts of other can do it. You just need to be aware that if you've got some hearsay, and there's hearsay baked into our problem, there's definitely hearsay, and you want to get it in, you have to first realize that this is hearsay, and then you second have to comb through the exceptions. You just have to do it. I mean, I can't tell you how many times I've done this as a lawyer who's tried many, many cases, and I want to get something in. How am I going to get it in? So you just need to go through the exceptions and try to find something that works. Okay, those are all the exceptions that apply when irrespective of whether the out-of-court declarant is available or unavailable. There are all sorts of other rules that apply only when the defendant is unavailable, things like dying declarations, former testimony. Again, we don't really have time to get into these, but understand that the world of hearsay exceptions is divided into two hemispheres, those that apply when the declarant is available and those that apply when the declarant is not available. Again, this is just something you're going to have to comb through if you have to deal with some hearsay. Authentication. This comes up all the time in trial ad, all the time. What is authentication? Well, it is a cousin of relevancy. We've already talked about relevancy, about how we're not going to allow something to go to the jury unless it matters, and unless this evidence tends to prove something that matters. So what we have to do before a judge lets in evidence, and by evidence I mean physical evidence or a testimony or a document, we have to know what we're all talking about. And take these glasses. If I want, for example, suppose I say, Your Honor, I offer into evidence these glasses. Well, are they relevant? I don't know. How does the judge know whether they're relevant? What do we have to ask? People in my evidence class, past or present. Surely you remember, if we had Kimberly here, she would know what to ask.
What are you trying to do?
What are we trying to prove? Says the person who sits 2 people away from Kimberly. Yes. You gotta ask, what are we offering this to prove? What are we offering this to prove? If I'm offering this to prove that these are really nice glasses and I have an eyeglass collection, I just want everybody to see my glasses. Well, not relevant. But if I contend that these glasses were on the scene of the crime and they have the defendant's fingerprints on them, these are glasses found at the scene with the defendant's fingerprints on them, are they relevant now in this murder trial with the defendant being accused of the murder? You bet. Why is it relevant? Well, because it's more likely than without this evidence that he's the murderer. So I need to authenticate these for what I purport them to be. If I purport these to be just nice, shiny glasses that should be in any person's glasses collection, they're not relevant. But if I purport these to be glasses found at the scene of the murder with the defendant's fingerprints on them, I need to authenticate them as such. And to do that, what I need to do is I have to offer evidence sufficient to support a finding that the item is what I claim it to be. So the starting point is, what do I claim these are? What do I claim these are? And here you can get kind of metaphysical about it. Because you could just say, Cialino, they're glasses. Yeah, on one level they are. Just like on one level you're a person. But on another level, you're somebody's daughter or son. You're the owner of some dog. You're a lot of different things. You're not just a person. These glasses are a lot of different things. On one level, they're glasses. They might be quite handsome glasses on another level. But on another level, they might be glasses that were on the scene of a murder. And if I purport that these are glasses found at the scene of the murder, I get to decide what I purport these to be because I'm offering them in evidence. So if that's what I purport them to be, I need to offer evidence sufficient to support a finding that they are what I purport them to be. So how do I do that? Well, I have to call a witness. For example, let's call Mr. Peter Policeman again. Peter Policeman, I need to authenticate these before I can get them into evidence, so I'm going to do that. So how might I do that? Well, again, it's not going to these glasses can't just walk in, no document can just walk in. That's legs. So we need to authenticate them to get them in. But this is pretty simple. 901 has a long list of things about what you can do to authenticate evidence, to get it in. And lay a foundation is another way to talk about authentication. But it's not difficult or mystical. And in fact, you can lay a foundation for most evidence with 2 sentences. 2 sentences. And remember what the goal here is. We're trying to put in evidence sufficient to support a finding that the thing, the document, physical evidence, the testimony, is what the proponent says it is. So here we go. We got Peter Policeman here. Mr. Policeman, here is what I've marked for identification as Plaintiff's Exhibit P1. What is it? Pretty technical, huh? That's what you're gonna say. Why, these are the eyeglasses I found at the scene of the murder. Are they relevant now? Are they relevant? Yeah, you bet they are. So now you can see that I've authenticated them. There is evidence now in the record sufficient to support a finding that these are what I purport them to be, namely glasses found at the scene of the murder. The judge will now let them in because I've demonstrated through my authentication process that they are relevant. The best evidence rule. This is a rule that is often misunderstood by lawyers, and it's not a rule that is, I don't know whether it's likely to come up or not. I'm not as deep into this problem as Professor Lassen is. I will be after the weekend. I'm sure you will be after the long weekend. You all on Monday are going to be making a week from Monday, are going to be making an opening statement from the problem, so you're going to have to know it cold. But I'm not sure if there are any original documents that we're trying to prove the contents of. But let's take my hypothetical. Suppose you and I reached an agreement and we wrote it down, and I'm going to cut your grass and you're going to pay me $20 when I'm done. It's a contract, we've reduced it to writing, we've both signed it. I cut your grass, I knock on your door, and I say I need my $20. And you say get the hell out of here. I don't know, who are you? All right. So I sue you for $20. I'm trying to prove that you and I had a contract in which you promised to pay me $20. You claim there is no such contract, that you've never seen me before. I must be a crazy person. So I take the stand at the trial and I try to offer this testimony. I met with the defendant, and the defendant told me that the defendant would pay me $20 if I cut the grass. Okay, is that hearsay? Sure sounds like it, but it's not because it's a party admission. How about that for a little cumulative information there? And the next question to me by my lawyer is, did you all have a contract? Yes, we did. We had a written contract that we both signed right there on the front porch of the defendant's house. What was in the contract? Well, in the objection, best evidence. Did you hear what I was getting ready to talk about? I was getting ready to talk about what was in a document. I was getting ready through oral testimony to try to prove the contents of a writing. You generally can't do that. Why? What's the principle? We don't want to hear about what's in a contract, a written contract. We want to see it. Don't tell us about what was in a video, or about what's in a picture, or about what's in a booklet. We want to see it with our own eyes. And that's what the best evidence rule. If we're trying to prove the contents, and this is where most people get confused, we're trying to prove what a document, a book, a photo, a video said or showed, bring us the contract, the document, the book. Don't tell us about it. An original writing, recording, or photograph is required to prove its content unless the rules provide otherwise. So, in our hypothetical, if you're trying to prove what some document shows, mark it as an exhibit and put it in. Don't have a witness testify about what some document or photograph says or shows. Let's see it. Get it in evidence. That's it. Of course, this rule then goes on to say if the document's lost, then we can take secondary evidence about it. We will then hear about what was in it. The rule also goes on to say that if you've got a photocopy of it, that's just as good as the original. But just for our purposes, if you're trying to prove the contents of a document or a photograph, just mark it as an exhibit and put it in evidence. Don't tell us about it. Yeah.
You said that most lawyers tend to misinterpret this. In what way?
Well, they try to suggest that you can never offer testimony about the document. I mean, if it's in, then you can explain what you thought that it meant. That's all allowed. But once we have the terms of the document, what they mean, how you got there, all of that's not excluded by the best evidence rule. And also, some people look at this as a rule of better and best. If they're, for example, if you've got an original and a photocopy, they might say, aha, well, you have to get the original with the ink on it. Well, no, you don't, because a photocopy is just as good. One's not better than the other. So, and they think that it only applies if you're trying to prove the contents of one. And that's really it. Opinion testimony. You're going to try to get into opinion testimony. There is an expert, two experts involved in this case. They're going to provide opinions, so you need to know the basic rules. Now, first of all, there are lay witness opinions, and we say this sort of stuff all the time. What's the rule of evidence on this? Generally allowed. Generally allowed, as long as it's rationally based on the perception of the witness. Rationally based. All these examples are rationally based on the perception of the witness, because cars speeding, somebody was drunk, shirt was purplish. All of these are fine, fair game for opinion testimony. Now, when it comes to expert testimony, much more complicated. You're going to have to qualify your expert as an expert in order to allow your expert to put in opinions that aren't rationally based on things the expert perceived, but based on the expert's review of documents and physical evidence. And you need to establish that it is an area that expert testimony would be helpful on, and that the person has the requisite education, experience, knowledge to be an expert in the matter on which she's testifying. So, and if the witness is not an expert, well, then they're not going to be able to give expert testimony. So, what you need to do we're going to have a whole class on experts. When we get to experts, and the book the Lumet book is good, it's got a whole chapter on experts. You're going to just have to get in, not super deep, but a little bit into what you have to do to qualify an expert, what some of the limitations are in expert testimony. And then we're going to spend really not much time talking about the evidence rules on experts. We're going to be talking about more the tactical and strategic use of experts at trial, how to ask experts questions, how to put them in the best light when you're on direct, and how to cross-examine them. So, but before we do that, you need to go to the 7 series, 701, 702, and see what the basic rules are for getting an expert qualified under 702. And again, that's all about showing that the witness has scientific, technical, or other specialized knowledge. And then you'll get that testimony in under 702. And this is 702, which is a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of opinion. So that tells you that prefatory language tells you that step one is qualifying the witness as an expert. And then once you tender the witness as an expert and the judge accepts the witness as an expert, then off you go to ask questions about the opinion. The other side, however, may object. Suppose if you ask somebody, now, Dr. Smith, you have examined all of the lines on the the defendant's hands, haven't you? Yes, I have. Some of those lines are long and suggest Can you tell from any of those lines whether the defendant is capable of murder? Yes, I can. Well, the other side should be jumping up, the defense lawyer should be jumping up and objecting, right? He's got all kinds of opinions, and he may be an expert in palm reading, but you would attack it because that testimony is not the product of reliable principles and methods. I don't mean to offend any of the palm readers among you, any of the tarot card readers, but you know, that's all junk. It's all junk. Sorry. It's not the subject of reliable prediction. Now, if somebody were to take the stand and say that, yes, in my opinion, 5 days out, everyone should have known that a hurricane force wind was more likely than not to hit that rig. Do you think those kinds of experts take the stands when people die on Gulf of Mexico drilling rigs after hurricanes blast through? You bet. People do predict the future, but not palm readers and tarot card readers. There's no reliable principles and methods for telling the future from reading palms, but there is from looking at satellite loops and sea surface temperatures and shear winds and whatnot. So when you're doing the expert cross-exam, mostly, be thinking about 702 and attacking the witness's testimony and arguing, first of all, that it should not be accepted by the court. It should be inadmissible when you're arguing to the judge on the issue of admissibility. And then when you're arguing to the jury as to the weight it should give the testimony, all these same factors bear on the reliability and how much weight should be given to the expert's testimony. Character evidence. Again, this is something that we spend a lot of time talking about in the evidence class. Very difficult to try to sum up character evidence in 5 minutes or less. But in any trial, whether it's a criminal trial or a civil trial, we have this basic fundamental principle. Is we want to try somebody for what they did or what the evidence shows they did or didn't do, not on the basis of what kind of person they are. I mean, if it's a murder trial, we don't want somebody some witness to come take the stand and say, yeah, I know the defendant, and boy, is he a hothead. That guy, you know, he looks at something and goes, woo, smoke comes out of his ears. He's an angry person. Is that persuasive? Yeah, it kind of is, because we all hate hotheads, and we know that a person who's easily angered is probably more likely to kill than a person who's not. So is it relevant? If we're just using our 401, 402 relevancy test, yeah, you bet it is. It kind of is. If you were to hear that somebody is just kind of a careless driver in general, oh yeah, she's a careless driver. Boy, she's driving with one hand, she's got her knee holding some coffee, and she's texting at the same time with her elbow. It's the kind of person she is. Well, is it more likely that she was involved in a car accident that was her fault than without that evidence? You bet it is. That's going to be relevant under 401, 402. But in America, do we want that kind of testimony? No, generally not. And that's what 401 and, 404 is all about. Character evidence under 404 is really what I call the shiny red ball in the courtroom. The minute it comes in, the minute you start hearing about what a hothead the guy was, or you start hearing about how dangerous of a driver she is, you just look at that and go, wow, man, this person, I hear the evidence, but man, everybody says that person just flies off the handle. It tends to overwhelm the decision-making process. And for that reason, the general rule is we exclude it in civil trials and criminal trials. We want this trial, whether it's civil or criminal, to be about the evidence, about what this person did or didn't do, not what kind of person they are. And that's what 404A1 says. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character trait. So we can't offer the fact that somebody's a hothead to prove that on the murder in question, he must have been a hothead. Or to prove at the time of the accident in question, she must have been driving negligently like she has a propensity to do. That's called propensity evidence. And generally, that's disallowed. Now, of course, there is this 404B exception. It's not really an exception. But under 404B says you can offer evidence that sounds like this, evidence of prior instances of bad conduct, if you're offering it for some other purpose that's not propensity. So, but I'm not sure whether those issues are presented in our problem, but what you need to do is to have an ear open for character evidence. Because if somebody is proffering some evidence about how good or how bad somebody is, or what somebody's like, or how they generally act, the antenna should be popping up on your evidence helmet and telling you, hey, wait a second, this sounds a lot like character evidence. I need to think about whether to object on the basis of 404. Or on the contrary, if you're offering evidence that sounds like something bad or something good that somebody has done, it sounds like your opponent's trying to get it in to show that they're just kind of a bad person, then you need to be thinking about the 404B and how to get that character sounding evidence in under some other evidentiary principle. So most of all, you need to be aware of this character evidence problem and be thinking about identifying character evidence when you hear it and how to work around it if the facts support it. All right, so those are my basic evidence principles in 48 minutes or less. I have 2 minutes left if anybody's got any particular questions.